Yes, so good morning once again and welcome. Let me thank the NCPC for organizing this, this webinar for us. We thought it was very important because these pieces of legislation have been in the making for some time now, and we have maintained a level of interest in their development. We've been lucky to have some of our members represented in some of the working committees that have been looking at the legislation, but we wanted to do a more general presentation to our members, and thus we invited and requested this, this webinar. So I want to thank you, notwithstanding the fact that we have not all joined. We are recording and we will make it available to them at some later date. So let me thank Mr. McNamara for being here and for taking time to make this presentation. So over to you, Mr. McNamara.
Thank you very much. Good morning to everybody. Let me see if I can use my skills and share my screen, because that's the... Okay, I believe I am sharing. Hopefully you can see my presentation. Is it coming up okay?
Yes, we can see. I can see.
Okay. Once one of you can see, then I've achieved my purpose. Good morning, everyone. So thank you for allowing me to present to the Chamber of Commerce with respect to the two bills, security interest in movable property and bankruptcy and insolvency bills. I'll sort of go through. These are the members that worked with the government to produce these bills. The bills are not in their final form. I'll explain what the sort of next steps are for the bills. But what you have before you, apart from the team from the government of St. Lucia, you also have members from the World Bank Group and also Toronto law firm Thornton Finnegan Grout, who assisted the World Bank. And then you have Neil Cohen, who has drafted quite a few international, well, the model law, I should say, with respect to security interest in movable property. So he also was part of the process as well. So quite a high caliber team of individuals assisted the government to bring these bills to being. The purpose of today is just for me to highlight some of the key aspects of the two bills, let you know what's going to happen, sort of where we are now and what's going to happen to bring the bills to fruition. And then lastly, a sort of a Q&A session. I believe that the best way for you to get an understanding of this is to ask as many questions as possible, and for me to attempt to answer them, hopefully in a satisfactory manner. And that way, hopefully you can begin to appreciate what these bills are about, as opposed to just me just telling you this is what they do. It's nice to put them into sort of a real world context. I'll start with the BIA. Oh, sorry, I keep on calling it the BIA. I'm so used to it. It's the Bankruptcy and Insolvency Bill. It's modeled actually on the Jamaican Bankruptcy and Insolvency Bill, which is the same as Trinidad, Barbados, St. Vincent, Jamaica, and they all stem from the Canadian Bankruptcy and Insolvency Act. And so it's generally referred to as the BIA by most practitioners. It has one simple focus, one simple aim, to assist those in financial difficulties. It provides a framework for debtors who are in financial problems to find a way to come to deals with their creditors and then move on. And simply put, if the deal is not struck, then unfortunately bankruptcy ensues. But the benefit of a bankruptcy is that when you're done, you're discharged from your liabilities and you can now move forward with a fresh start. So that applies to individuals as well as to corporations. The two key features of the BIA, the proposal section and the bankruptcy section. You can almost divide the act into two. Bankruptcy is sort of a dreaded word, but everyone knows what it means. You can't pay your debts, there's no solution. So a trustee is appointed, gathers in all your assets, save and except for those which are excluded, and liquidates them, pays everybody off. And if you're an individual, you essentially get a fresh start. You have no more debts owing to anybody, and you get to walk back to the beginning and start yourself in life again. The idea is that, you know, people who are entrepreneurs or people who enter into business, often on occasion things will happen and it doesn't work. The idea is not to punish them. The idea is to allow them to become economic drivers again. So instead of just paying off endless bad debt, you bring them back into the fold, and they can now help with economic drivers without having to be burdened with bad debt. With companies, it's a similar process. If it goes into bankruptcy, everything is sold. And the company, for most parts, they're normally killed off by way of liquidation. But if for whatever reason someone wants to keep the company alive, in theory, it'll go on and start life back again, back at zero. The sort of new feature on the legal sort of landscape would be the proposals. It's new in that this is a moment in time where a debtor stays in possession of all their assets and their business, and can now go to creditors and advise creditors that, look, I have financial problems, but I believe I can solve them. Most creditors will understand, if they don't already, that when you liquidate, value of the estate dissipates. Anything that's in a bankruptcy or liquidation is sold off at a fire sale. But if you restructure, you save value and allow debts to be paid off as best they can over a longer term, but you get a better reward. So the idea is you would, as a debtor, go to your creditors and say, I think that I can pay you off, or I can do certain things, and it's whatever you can dream of, basically. It's your proposal to deal with your debts, settle them off, and if you agree, it will become an official plan of the court, and I have to live by it. You have the benefit during the proposal of having access to professionals. To do this, you have to engage with a licensed insolvency practitioner. That's the phrase used in other jurisdictions, but just call it a trustee in solution. And they are professionals who understand and are skilled at a certain level, at the higher levels, to deal with financial problems. And so they will assist, they will review your plan, and if your plan makes sense and is viable, they will endorse it. And that allows creditors some level of comfort that the plan will succeed. And hopefully when you review the plan, a creditor will look and say, oh, wait a minute, this actually will allow me to recover more of my money, be it over a 5-year period or whatever the period is, as opposed to me enforcing a liquidation and getting cents on the dollar. So those are really the two key features of the BIA. The main stakeholders of the Act are simply the debtor, because this is meant to be a debtor-driven process. And as I said, the debtor stays in control of the assets. You have the creditors who get to turn up, and the Act, at present, we have a very confused list of priorities in St. Lucia when it comes to where everybody ranks. So much so that I even think it's currently, well, I know it's before the Privy Council for debate later on this year. But this will now tidy up and make a very simple ranking for creditors. I'll discuss a little further, but essentially you have secured, preferred, and unsecured. Secured are meant to be banks and people who lend and take security for their lending. Your unsecured are generally your trade creditors, people who will give 30 days. So a lot of people on this call would generally be unsecured trade creditors, people who will, give products and expect to be paid in 30, 60, 90 days. Preferred creditors tend to be ones that are given preference by virtue of law. So your taxes, your NICs. There are others, for example, people in the construction industry are given certain liens. People who work on products are given liens, and these exist in civil code, and their priorities are still sort of maintained. The biggest sort of news in the BIA, which should help everybody, is, and I'll talk about it a little more further down, is the fact that the government is going to, instead of ranking first, they're going to limit their rank. The government has basically said that for the purpose of bankruptcy and insolvency, the government will take 2 years of all taxes as secured. Everything else will be unsecured. They did say that all sort of what I call trust taxes or throughput taxes like PAYE and VAT have to be paid, but everything else goes on the back burner. So that will allow companies a little bit of more of a breathing room. Most practitioners will know that whenever they're doing an insolvency or receivership, the biggest hit tends to come from out of the blue, which is, how much the government is looking to take. And the government before did not bend on its taxes. They wanted everything. But the best model for taxes in most countries is government gets nothing. They're unsecured. Considerations have to be given for smaller states like St. Lucia. So the government conceded that they would take some, not all. The last the last key person is the trustee. You now have someone who will be governed by the supervisor. There will be a requirement with respect to certain qualifications, which will come out in due course. But generally, and you will get those normally who are accountants. There's access to some lawyers doing this, but you'll generally get the guys in finance who've spent a lot of time doing restructurings, receiverships, and liquidations. They will most likely be your licensed trustees going forward, and they will have the understanding and the skill set to deal with the financial restructuring of either the individual or the corporate entity to allow for its success post-restructuring. In terms of the process, there really are only two key features you need to bear in mind. Whenever the act is engaged, there is an automatic stay of proceedings. So be it if you start on a bankruptcy or you start with a proposal, everything stops. No one can move against the debtor. And this allows for the proposal to be brought to life. So you give yourself a 6-month maximum window in which you can formulate and work with your creditors and your trustee to develop your plan without having to worry about creditors attacking you. No one can. Also, essential services can't stop providing you services. So, Lucilec just can't turn the switch off. Telephones, internet can't turn off. Everybody who's providing you services, and if there's a debt owing, they can't turn you off because of that debt. What you have to do is everything from the date of the commencement of a restructuring process, anything before is stalemated and held in abeyance. But you will, once you enter into restructuring, have to keep your current bills alive. So if you're a company, for example, and you go into restructuring and you owe Lucilec $10,000 and you owe Flow 20 and you owe Wasco 5, and they're all saying we're turning off, they actually get stopped. They can't touch the services. You do have to pay them as you go forward. And part of your process is to create a cash flow wherein you will notice that you have to say, right, my monthly expense for whoever it is $500 a month, and I have to cash flow that in, and you will have to pay that. So go forward is covered, but historic is dealt with in the process. But that gives you the period of time to sort of fix your affairs and determine how best you're going to go forward. Either way, whether it's a bankruptcy or a proposal, what you really have is an orderly resolution for creditors. So be it's a winding up, trust or liquidation or bankruptcy, the trustee takes everything and follows the list, sells it all and pays everybody 1, 2, 3, 4, done. The benefit, one of the stalemates that practitioners used to face is that you had all these judgments on land and creditors would sort of not allow you to sell unless they got paid in full. That has been lifted, whereby a judge can now intervene and basically remove all encumbrances on property so the trustee can move forward and sell in a nice, clean manner. And that allows for everyone to be paid in accordance with rank. The key thing for any restructuring is the rank system and ensuring that nobody can interfere with it. And the same applies with a proposal. When you are doing your proposal, if you need to sell assets as part of the process and creditors are getting in the way, a judge can intervene. If you are making a proposal and you have a few people who don't want to buy in, once you get the requisite number of votes, everyone has to abide by the proposal and the plan. And that means you get to move forward with a clean slate according to your proposal. As I said to you, the key takeaway here really is the taxes, because that was something that was on everybody's mind and the government has made its concession and it's only 2 years. That also applies to NIC as well, because NIC lives in that same realm. So those are those key takeaways with regards to the process. There are two unique features that I want to mention with respect to this particular iteration of the BIA. Other places don't require a trustee residency requirement, not that I can recall. Barbados does, I believe, but most places don't. There are going to be certain requirements for trustees, residency being one. There's also going to be insurance and other qualifications. You have to be of a certain standard to become a trustee in St. Lucia. And the new feature, which I'll get into more, is what I call enhanced protection for certain individuals. In other jurisdictions, the government and the legislatures have found that it's important to protect those in agriculture and in some occasions, individuals who have been sort of really hard done by. Now, in St. Lucia, the government decided that what they were willing to do is assist those in agriculture, that's the fisher folk and the farmers. And also they wanted to carve out for those people who, for whatever reason, their circumstances are so dire that they do need help. The example I keep on giving, and I don't know if it's the best example, is you have a young family, husband, wife, couple of kids. All they have to their name is a very small home, which is not overly valuable, but valuable to them. And if you were to put them into bankruptcy and a bank is pushing, for example, to sell the house, you're basically going to have these people homeless. The government was very concerned about that aspect. Said, okay, if the person just doesn't want to work, they can't stay in their home forever. But imagine someone who has suffered an unfortunate accident, cancer has put them down for a couple of years, they're coming out of it. You don't want to be able to push that person and make them homeless. You want to be able to afford them some time. This is fairly unique in that it's not always what's there in other laws, but the government was quite adamant that they did not want the act to be abused by large creditors on what they call the small man. So what we have in this act is a feature whereby if you qualify, that is to say purely on humanitarian grounds, and there are some definitions in the act as to what that generally means, then a judge can assess you and say, okay, your circumstance is so unique and requires so much sort of humanitarian aid that I am willing to invoke these extra powers. And the extra powers are essentially permit a judge to stall any execution or any sale of the family home. The only thing it protects is the family home for a period of time. So the idea being you can't just live in your house forever without paying your debts, but if your situation is such that you just need a year, 2 years to get back on your feet and deal with your debts, a judge can move in and stall the process for a period of time. If a judge believes that there is no qualification or no justification for the enhanced powers, what we have done is created a tribunal. Actually, we just sort of hopped onto the tribunal created by the Income Tax Act. So the commissioner, the body of commissioners in the Income Tax Act will act in 2 roles. They will come over, and because they are financially minded, but also members of society, they will be able to assess the person's story before them. And if they believe that this individual deserves extra protection, they can award it, and the court will then abide by that ruling and invoke the extra protection. So it's an attempt to balance as best one can the most unique and sort of heartfelt situations that on occasion need to be dealt with the brutality of law. Law tends to be something that just goes either on one side or the other, and you have to recognize there are gray areas on occasion. So this unique feature tries to encapsulate and give life to the gray areas where sometimes individuals need a little bit more compassion for whatever reason. With respect to fisherfolk and farmers, it's also understood that they form a very key part of society. They are essentially people, individuals who feed the nation. And if they are to go into a restructuring process or to bankruptcy, you still need them. You can't obviate, you can't wipe out the fishing industry, you can't wipe out the agricultural industry. So how do you ensure that these individuals can come back after a bankruptcy event or a restructuring event? A similar process. There are enhanced powers whereby a judge can say, instead of you keeping 30% of your assets, I can actually allow you to keep 50% of your assets. So you can imagine a fisherman just has a single boat and a single engine. Well, one may say after you sell everything up and you put it together, 30% may mean his boat gets sold. But if it's 50%, it means he keeps the boat, and that means he can go back fishing. If you think of a farmer and he has 3 acres of land, well, if you get rid of 1 acre, which is 30%, okay, that may not really assist him in really getting back on his feet. But if you give him half of that, 1.5 acres, maybe that may help him. And it's a matter of assessing the circumstances. As I said, everything is always done with the trustee in the corner to determine whether this is a good or bad idea. So you have that backup benefit of an independent person, but there are situations that need to be dealt with, and that's what this enhanced powers and protections are about. What's going to happen once this law passes is you're going to remove the current bankruptcy provisions that are in the civil code, commercial code, sorry, which I don't think many people even know about, but they're there and hardly used. We are looking to amend the Bankruptcy Act will amend other laws, and one of those is to make sure that whenever a liquidator or receiver come in to being, that they are also at the level of an insolvency trustee. The idea being that persons who are going to be given these tasks are at a certain level and they can practice, and you're basically bringing that whole industry up. As it currently stands, anybody can be a liquidator or a receiver, and you're dealing with people's financial lives, and it shouldn't just be open to anybody. So we're now imposing qualifications on people in this space. The Act does sort of get involved with the various taxes and duties. As I mentioned, the government has given a concession, so that will affect some of those taxes and how they're paid. Civil code is obviously going to be affected because civil code creates a ranking structure and also creates hypothecary obligations. Well, the BIA will come in and supersede that. And the Companies Act, which currently governs receiverships, will also be overtaken by the BIA because receiverships will now come into the BIA. Just on a practice note, most people are used to banks appointing receiver by what they call out of court process, and the banks invariably do so and indemnify receivers. The practice in other jurisdictions is no one does that because nobody wants to indemnify a receiver. So a lot of people actually use their receivership powers that are in the BIA to appoint receivers going forward. So it's because it's now a particular office governed by statute, a lot of people invoke this means of putting a receiver in place. It also means that if you do not possess, while it can be done anyway, if you are a creditor and you want to put a receiver in, it also means you can utilize this act as well. So it sort of makes access to receivership more available to or easily available to all creditors. And that's really sort of it for the BIA. I don't know if you would prefer to get into Q&A now, which I'm happy to do, before I move into the security interests on movables, or whether you'd like to wait to the very end. Brian, I'll let you lead that discussion.
I think we should go through all of it, and then people will pose the questions afterwards, if you don't mind.
Not a problem. I'll continue.
Thank you.
Sure. So the second bit of law that's coming into place is security interest in movable properties. It actually is a very simple bit of law. It's going to remove from sort of what we have currently, which is a whole hodgepodge of various laws. Hire purchase, I think, has been repealed, but we have the Agricultural Credit Act and we have Bill of Sale, and they all turned up over the years in different forms. This is meant to be a simplified version, and it basically allows anybody to give any movable asset up a security. That's really what it comes down to. And the key feature of doing that is notice. So what you have is a framework where you will create a security interest. You register it in the new registry, which is electronic, and everybody will know about it. So then when you come to enforce, no one can say that it was, I didn't know. The whole world knows. That's the benefit of it. What will happen is parties can make any agreement they want. Now, there will be protection. The Consumer Credit Act and the Consumer Protection Act do put in place formats that dictate what and how an agreement where a consumer is giving security, what it has to contain. So, you can't be abusive. You have to give certain details. You can't be, hiding terms. Terms have to be clear and apparent. So whenever there is a consumer credit happening in this manner, you have to ensure that you abide by those terms. So that will at least give, for about the small man, I don't like that phrase, but it'll give the individual or a company who may not be as sophisticated as, say, those in the banking world, a comfort and security that the banks, for them to be able to enforce their security, have to comply with these protection acts. But once that is done, it's carte blanche. Between you and the lender, borrower and lender, you can make up whatever you want in terms of an agreement. Once that agreement is signed off, then the lender will invariably take their security agreement and register it against in the registry. Now, the cost is meant to be minimal, $20 to register a security interest. The idea being is, and this is where it may come into importance for those in the chamber, you're a business, you sell high valued products. You want to lease out or sell excavators, you want to sell photocopiers, things that cost lots of money, tens of thousands of dollars. You can simply create a security agreement where the person's going to pay you off, or the vehicle or the movable is the security item. Create a simple form agreement, run down to the registry, which I think is meant to be online, so you can even go online, and you will register against that person, individual, company, whoever it may be, and say, you have given me a security interest. You don't necessarily disclose all the details of your private transaction, that's not appropriate, but you do let the whole world know that as between one party and another, there is a security interest. So if third parties want to transact business of a credit nature with someone who has already given up assets, all you would do is go to the online registry, search the person's name, pay your search fee, and if their name pops up, so let's just say I have gone to Northwest and I have bought a car, and they finance it for me, then Northwest will have a security claim against me. It'll be registered. So if you type in my name will pop up. And if I try to do something like get credit, or I try and sell or deal with this vehicle in some way, a quick search will reveal that Northwest and myself have something going on. And then you can then dig deeper. If it affects the vehicle will obviously be named. But if there's some other deal, you can now request those documents. And so show me what your deal is. And now everybody's aware that I have given security in my vehicle to Northwest. Don't buy it, because notice it to the world, and you will no longer be deemed a third party for value without notice. So that will allow Northwest security to go right to wherever the vehicle is and reclaim it, because their security interest never dies. And that's the benefit of having this registry, and everyone can use it. It'll be easy to access, easy to use, and the cost will not be prohibitive in nature. Anybody can turn up and just file their security registration. Enforcement of these security interests will be as per the agreement. So if you give somebody the right, just like a bill of sale, to come and repossess the property, that's what's going to happen. Whatever's in the security agreement is what's enforced by law, and you'll be able to go and collect it, garnish rents, whatever your deal is with respect to this property will support you. What will go? Bill of Sale Act. The Hire Purchase Act, it was already repealed in the Consumer Credit Act. So that's gone, but essentially the Consumer Credit Act, which now assists, will live parallel. What you have basically is the Consumer Credit Act will govern the contents, but the security interest will govern the granting, registration, and enforcement of security. And then the Agricultural Credit Act will also go as well. Moving forward, we have to do a few amendments in the Civil Code and the Companies Act, just because things like pledging will no longer exist, because that deals with how you secure movables. That'll be gone, and that'll be governed by this act. And the Companies Act, when you deal with granting of mortgage debentures, and the debenture or movables will now kick in. You will create your debenture, which will create a security charge, but you will now take it and register that in the new online registry. There will be, we have to sort of deal with the stamp duty aspect. Right now, the stamp duty ordinance says whenever you deal with one of the things that makes security interest in movables prohibitive right now is the amount of duty you have to pay. And so a lot of financial institutions, don't always register. For example, pro notes. No one registers a promissory note. It's just too taxing. Again, bill of sales would make it prohibitive for everybody who's out there to always register. You can imagine someone who deals in secondhand cars or some other sort of business, for them to do a bill of sale every time, that's going to affect their profits. So the stamp duty ordinance is put aside, and whenever you register a security instrument in accordance with this act, you pay these minimal fees. So all these things are brushed aside. It's to make it a more cost-efficient for the people who are creating credit in the system. And that's really it in terms of the security interest. It is a very simple act. It works very well. It's a model law that was created in the US. It works in Canada, and it's been implemented in other places. It's just a simple way of saying people can do whatever they want, secure whatever they need to secure to get money. It's just a way of getting credit. And it's a way of those giving credit to have some level of security and comfort that everyone out there will know that they have given credit and they have some sort of security over items. What will go forward now? Said the bills, they make a single unified security system, and the BIA deals with, a uniform system for restructuring. I have to say that they were well drafted. I was not the person who drafted them. They were drafted by the team that I mentioned earlier on, who are all experts in their respective areas, and they do exactly what they intend to do, which is create these new regimes, which my job is to make these new statutes harmonious in the legal framework of St. Lucia. I hope I have succeeded. What will happen next is the government has sort of taken all the recommendations that have been put forward by the stakeholder groups, of which the chamber was one of them. And we have essentially got to the stage where it's for the drafting unit to just tidy everything up. I think all the recommendations are in, and at some point they'll be put into the draft and the final version created. My job is to work with the Attorney General's chambers to do just that. Okay, I have a body of answers from everybody, and I will work with everybody to ensure that those recommendations are put in. The World Bank would like to have another look at it all when it's all said and done, to make sure that their work product is still intact. And then final version goes off to cabinet, final version goes off to Parliament. I believe there was an aim for sometime in March. I don't know how everyone's focuses are, but that's the aim. That's it. I think that brings, if that all happens, the acts will come to life.
Thank you very much, Mr. McNamara, for your presentation. Fairly explicit. I appreciate that, even without having the legal mind or the financial background like many of my members do have. I do understand very much the implications and some of the mischief that will be cleaned up, if I could put it that way,
yes,
in this piece of legislation.
Yes.
So I wish to invite the participants to raise questions and queries. You could just signal and go ahead. First person. Richard, you need to unmute.
I'm unmuted.
I can hear you, yes.
Okay.
Yeah.
So I've been through about 10 of these with Buta, as he knows. And every time I come to one, I always get a few more questions. But, I'm beginning to feel like an expert after his great presentation. And there's been a bit of change as a result of, some questions that people had and some suggestions of others. So I got a couple of questions, but I'll start with maybe two and see if anybody else wants to come in, and I'll ask the others later. So the first one is a simple one. Does every proposal by a debtor have to go through a trustee? Or is a debtor, okay, that's simple, that's a quick answer. So it's not a case where if I, for example, was the debtor, do I have to go to a trustee? Although that's kind of moot because I would be the trustee, but still. So the answer is yes, and that's simple enough. And the second one you answered, which is the legislation that's repealed. And the third, and then I'll stop and let other people. Now, I think one of the intentions was to avoid the court having to be involved, on too many of these things, and allowing, in essence, the trustees and the creditors and the debtors to come to agreements without having the court or a judge. So does the court only intervene if requested by the proposer trustee, or if required in order to remove a charge or something like that? Or again, is it a standard procedure on every proposal that it must have court sanction?
So you are right. We did try to minimize court intervention. There was some question mark as to whether or not the supervisor had the right to grant certain extensions of time. So it basically works like this. The only time you really need a judge during this process initially is to give extensions of time, because it's a fixed period. 30 days is your first period of time when you make a proposal to make a plan. And if you're working very hard and your problems are difficult, you can get an extension. And it goes in 45-day increments, all the way up to 6 months. That's the maximum amount of time you're allowed. And then once your proposal is ready and you put it to creditors to vote, once that process of voting and approval has occurred, the judge then signs it into basically an order and signs it into life. So those are the two times you need: extension of time and approval of plan. Those are the two main judicial focuses. You really did not want to engage the court too much in the process, so you essentially allowed the supervisor to grant extensions. The criteria is the same. The proposal trustee has to say, yes, the debtor is working very hard to assist in the process, and therefore they get an extension of time. But there was this question mark as to whether or not the supervisor would have the capacity to keep on granting extensions. So we actually made it both. You can decide as a debtor whether you want to run before the supervisor to get an extension or the court. So I guess the reality is, if you're dealing with a complex issue and you have a bunch of creditors coming after you and they don't want you to get an extension of time because they want you to go into bankruptcy, maybe you want a judge to get involved. But if you're dealing in a very simple, harmonious process, everybody's working together, it's just paperwork. Can I get an extension? Yes. Here's another 45 days. You would go to the supervisor. So we created a mechanism for both. So it minimizes the cost. The idea being, I would imagine, for example, a situation whereby if you have an individual who doesn't have a lot of finances available, they are actually allowed, or they will be directed to go to the government trustee. So the government has a burden on their shoulders to create this office, and that office will essentially simplify and guide people for what I call simple restructurings. When you travel around places where bankruptcy and restructuring is a business in its own right, so if you drive around America or Canada, you'll see in trouble, debt relief, you see it all the time. All these people are doing, who are advertising these solutions, they've created a standard formula. You owe 10 grand, I'm going to go to your credit card company and make it 2, right? Because everyone knows if I had to go to court and argue it, a judge will make it 2 anyway. So it's just paperwork. So what the idea being is that between the supervisor and the government trustee, you will create a low-cost method for individuals to turn up, get some basic knowledge, fill out some forms with their details. The government trustee will then assist them and go, okay, yep, your proposal makes sense. Let's go get some extensions of time from the supervisor. So that's, again, no lawyers, no costs. And then there will be a requirement when you need to get it approved by the judge. So that process is any time you need to sort of go to court. But again, the government trustee is actually the one, once the proposal is approved, that will then go to the judge for the sign off. So the government will then say, all right, one of our lawyers will go to court, get it signed, and you're done. So there will be some hiccups, but the idea being is for the low cost individual restructurings or bankruptcies proposals, that will be done by these 2 government offices, and it should just be a simple paper pushing exercise. Because when you get into high numbers, obviously there's lots of money involved. There'll be availability to engage professionals because the issues will be more complex. So that's sort of the division as I see it in the Act.
Just a follow-up to that, and that would, in situations where clearly you're trying to get agreement, and hopefully you would get them within 30 days or an extension. This morning I went to court on a liquidation matter, as I have been doing now for 3 years, because it's so difficult to sell the property.
Yeah.
And each time, I'm getting an extension of 6 months. I'm not really applying for an extension, but I guess I have to kind of report to the court. So today, thankfully, she took me off the list so that I only apply if I need to.
Yeah.
But in situations like that, where, you're dealing with, in essence, a piece of property, in which you come to an agreement, but it's dependent on the sale of that property. We all know how long it may take to sell. So it means a 30-day, then you have to get an extension and another extension. But presumably what you're saying, you can get that from the registrar.
Yeah, the supervisor, yes. You get an extension if you're selling, but the only time that'll be sort of a complex scenario is if you're trying to sell something inside the proposal time frame. So if, for example, you imagine you have a company with 3 pieces of land, and to be able to make a proposal, you really have to sell 1 piece, and it's key for whatever reason to sell that asset during the proposal process. That's going to be a tight issue, and I think the experts who are involved will sort of say, we can't sell this in 6 months, so you can't this won't be viable. So it'll be a judgment call for yourself as a trustee to work out whether you're looking to sell, because the BIA has a very hard stop. If you don't have a plan and have it approved in 6 months, you're out. You go into bankruptcy. So you have to have a plan. So if you're looking to sell assets to generate income for a plan, and you can't do it in the proposal period, you're going to have to then put that into your plan and say, listen here, guys, when I sell this piece of land for X amount, it'll come into the pot and that will fund everything else. So that's my plan. And I'll put it to the vote. If it's approved, then I have to stick by it. I have to now ensure, and the trustee will continue to ensure that that plan is followed through till the very end. So the land will be sold, whether it takes 6 months, a year, the money comes in, that's now used to pay off whatever it was designed for, and then the plan continues. So you may very well be stuck with assets that aren't going anywhere. That's just the reality of the marketplace, and no one can be blamed for that. But you have to either put in a plan and get it approved, or try and get it done before the proposal process is completed.
Okay.
Shama, you see you have your hand up? Go ahead. Shama, you still with us? I note your hand is up.
Yes. Good morning, everyone. I'm not a business practitioner, but I would imagine that they also have mortgages and loans and whatnot. So they would be interested in finding out, when we get those extensions from the courts, does it affect the interest rate at the end of the day? Does it make the debtor worse off?
So what happens, one of the criteria for an extension of time is, whether there will be an adverse effect to the process, any prejudice that may come from an extension. The assessment of that normally lays with the proposal trustee. Invariably, an accrual of interest does not generally represent some sort of adverse effect. It's understood that interest will keep on running. The only difference is that, and remember, this is a world where you go into compromise. So if you're a bank or a lender and your interest is accruing throughout the process, you know that if someone has come for a proposal or is making a plan, they're going to ask you to make a haircut, be it in the interest accrued, be it in the principal accrued. They're coming for a deal. Now, it's up to you to determine whether you think that's a good idea or not. You may very well say, look, I'll waive all my interest. I will redo my loan, extend the period. So, if it's a mortgage and you're down to, 10 years left, you may very well say, okay, I'll just refinance this loan, waive my interest, and I'll give you 20 years to pay. Because if the asset, for whatever reason, has depreciated in value and you liquidate it, you may only get half your principal back. But if you give the person 20 years to solve the problem, they can afford the reduced payment because they're still working, and you get your full money back as a bank normally does over an extended period of time. So there's going to be a game played. The minute the proposal the minute someone says, I'm restructuring, something's coming at you to redo. But the interest never ends until a new deal is structured. It keeps on clocking up. Did that answer the question, or is there a concern that I missed?
It answers the question. So essentially you're saying that in terms of the interest, you as the debtor have the opportunity to negotiate with the bank.
Yes. The whole idea behind the BIA is to give debtors strength. That's why it's a debtor in possession or debtor-driven statute. The idea is you, with the force of this act, can turn up and tell creditors, look, I know I have a problem. I'm here to deal with it. You can't get blood from a stone. Here's all I have. You can try and liquidate me, but that will achieve $1. If you work with me and restructure everything, I can pay you 80% of your debt over a period of time, or I can pay you 100% over a period of time, or whatever deal can be worked on for all sides. It's meant to be a collaborative concession-giving effort. It doesn't allow the debtor to walk away and forget his debts, because that plan, once agreed, if a debtor fails to abide by the plan, they go into bankruptcy and lose everything. But it's meant to be an analysis of what's gone wrong, why are we here, what can we do to make it better. You have the experts in the guise of the trustee who understand the feasibility of a plan, understand the history of how you got here, and understand what the future may look like, and can say, yes, this will hopefully give everybody the best result. And so you will get a restructured deal and move forward.
Okay, thank you for that. I think it was a question that I had to ask because as the officer working on the reform, a lot of persons commonly ask that question. How does it affect your interest rate at the end of the day? So thank you for that. Also.
No problem. My pleasure.
The questions, Richard?
Okay. Enhanced protection, that we went through that one. That was interesting. At what point does the court really intervene? I mean, you have, the act would specify who is enhanced, so to speak. And that is, therefore, the trustee is going in accordance with that. But if for some reason there's some gray areas as to whether somebody really is enhanced or not, and I'm just not quite sure when they intervene and at whose request.
Well, it will have, again, this is a debtor-driven process. So the debtor will have to ask for the intervention. The enhanced powers do not come into play unless they have been approved. So if you're moving along, and obviously an individual who can have access to the enhanced powers, once they find themselves in the process, and with the assistance of their trustee, be it a government trustee or someone that they have engaged to help, once they have determined this is a circumstance that would qualify, the debtor would then make the application to a judge and say, look, I have these problems, and I believe that they reached the level that will allow you, judge, to give me the enhanced powers. And the way we sort of phrased it, because there was sort of a question as to whether or not a tribunal could overrank a judge, is that if a judge is going to deny that request for enhanced protection, they will refer the matter to the commissioners who will review, and if the commissioners accede to the request for enhanced powers, the judge will then act on those enhanced powers. So it's a matter of just unlocking them. You don't get them automatically. You have to be in a very unique situation to get them, and you have to ask the court for them. No one's going to give you these rights automatically. So again, data driven. If you think you need them, you go ask for them.
Okay, but so as a follow-up, and specified in the Act, as to who now, based on our present society, the government has decided needs enhanced protection. But things change, and over time, other segments of society, other types of creditors, etc., may become enhanced. In order for them to be into the Act, presumably that would take legislative change, an amendment to the existing BIA, for them now to be to get into the list, I'm assuming.
Yes, if you wanted to, right now it's individuals and fishermen and farmer folk. Those are the only people that get enhanced protection. If you wanted for some reason to give enhanced protection to construction workers or to I don't know, to lawyers, I don't know who you'd want to give them to, but you'd have to go back to the Act and change. But I mean, I'd have to say that if this enhanced provision, I understand the reason for it. There's a very human need to assist those in society who have really taken a beating. Life has really put them down. And to allow them to rebuild. Not to go into but if you sort of understand a little bit, or if you ever had any desire to understand the jurisprudence of St. Lucia, because we are based on the Napoleonic Code, and Napoleon basically came and said, well, I'm taking from the rich and helping the poor. The code itself is always being designed as something for the people. It's always been there to protect, which is why you find like hypothecs, really cumbersome tools of protection. There's no power of sale in a hypothec. You can't just take someone's land. It's meant to be that there's a process. So that the Napoleonic Code really varied who in society it protected. So the jurisprudence of St. Lucia has always been to protect the smaller man. I really hate that phrase, but that's what it was designed to do, as opposed to some, the laws in England, which tend to be maybe more driven by those who can lobby government for more capitalist-based, type laws. So that's what we have. We have already in St. Lucia a concept whereby the big man has to sort of, be a little frustrated to get over on the small man. And this is basically what this Act is about. This Act is always about, and it's the Act that exists everywhere else. It's sort of the new trend. It's to allow someone who has fallen down the right to come back. And you're not allowed to be bullied in that process. So yes, we now have a circumstance whereby the small man and everyone else gets to push back, but it's not meant to ruin the balance of an economy, because on the other side, people, if you give the small man too much power, people won't lend money. This is meant to facilitate enhanced credit in the system. These two acts are meant to allow for free movement of funds. Lenders now know that they have a clear guideline. If I give money, I know how I'm going to get it back. And I know what methods they are. It's either a restructuring, where I take a haircut or I make a deal, or bankruptcy, where I get money back on the liquidation process. It's clean, it's cut, I know where I am in the rank, I'm simple. And that's what it's meant to be for lenders. And for debtors, it's meant to be, if I mess up, it's not the end of my life. I will not be bogged down by bad debt forever. I can come in, make a deal, and get on with my life. And rather than be throwing money in bad debt, I can now utilize my money to become an economic driver. I can now become successful. So we have that in St. Lucia, where we always were trying to protect the small man, as it were, but now we have something where it's actually meant to lift them up and get them going again. So I hope that helped.
The wording that you probably need to use, if you don't like small man, you can go with bourgeois and Mallory.
Yeah, I mean, I can use that too, but even those I don't like. I mean, I just, but it has been said to me so often in this process that they want to protect the little man. And I don't know, that's just a personal phraseology thing, but I understand what they want to do. They're just, unfortunately, in society, you have people who need extra help.
I suggest you use the phrase, the average citizen.
Well, even then.
Because the average citizen is poor. The average citizen, and as I said, I love the historical context, because a lot of people forget that. And so they sometimes don't understand why we are where we are and what we're seeking to do. And I think if we understand what the original act sought to do, the question we ask is there still that need? And if that need still exists, how do we then, in a modern environment, translate that intention to reflect the continued need to do that within the modern context? And it is the average citizen. So I think rather than saying the small man, I say average suggestion. I think the average citizen maybe the
average Englishman on the Clapham omnibus, right? Last question on the brutality of the law, or not, the equity of it. In those instances where a judge intervenes and removes a charge, or comes up with whatever is necessary, what people have gone to court for, is that subject to appeal, and can that go all the way to the privy?
Everything is subject to appeal, so that's the reality. The ruling of the commissioners to grant enhanced powers in of itself cannot be appealed. It's either you get the enhanced powers or you don't. It's a yes or no answer, right? How a judge then decides to utilize those are always open to appeal. But I would say one thing: discretion. A lot of bankruptcy and restructuring law is judicial discretion. There will be guidelines, but a lot of it is the discretion of a judge. And it's so that a judge can take control of what's going on for the best outcome of what's going on. It's very hard to appeal discretion. The Court of Appeal in St. Lucia has said, if you want to appeal judicial discretion, there's a test. I'll try and paraphrase it, but basically the order was so out of sync with what a normal person would give that the judge clearly used bad law and bad facts for their discretion. And that's a bad paraphrasing, but that's generally, it's a very high standard. When a judge is applying the discretion, the higher courts have said, it's on you. The law has given you the right to determine what's best in the circumstances. So you can appeal. I don't think you'll always be successful on a discretionary appeal, but it is available to you, yes. So if someone has gone out of sync, you can go up the ladder.
I got some questions on the security, if everybody else is finished with the BIA.
Richard, go ahead. We don't have too many questions.
Okay, can't remember if we talked about it, but what about intangibles, patents, things like that? Can they go on the registry and how they're defined? And then the kind of add up to that is, if in a debenture, as we talked, you have movables as a security, so you can now go in, this is the bank, can now go in and register those. the nature of movables is kind of wide, you know what I mean? How does a bank define movables that may change? Whether it's the receivable or anything else like that, or something that you buy later on in life that's a movable, which he was covered for under the debenture. But now, you know, it's something that it means that every time that particular creditor, debtor, sorry, goes and gets, he's still in business and he gets some additional assets, he's including or selling some of his movables. And you know, so the question of how do you register that amorphous type of asset?
Yeah, it's again, the key to it all is always going to be the security agreement, what's in it. So most security agreements where you have movable goods as a transitional item, so stock in trade in and out. Remember, the charge itself never kicks in or crystallizes until it's called upon. So the reality is you have given a security interest, but it does not actually crystallize on the movables until there is a trigger event, invariably a demand or the appointment or whatever the event is in the act. So for most times, whenever you give a debenture, things just flow. There is no actual charge on those items. You will, so as a person who goes to take any of the members of the chamber, they all run businesses, they all have assets, they may have gone to a bank and said, please give me money, mortgage debentures on it. And they're just stock in trade in and out. None of that is affected by the bank's charge until the bank crystallizes. The bank will obviously put notice to the world, hey, everybody, just letting you know, I have a potential charge on everything in this business. If somebody wants to do a deal where they actually want to involve themselves in buying the property or buying the business or whatever the problem is, they can now go and confirm that, yes, you do have a valid charge, it's registered, I want to see it because I'm coming to buy half the stock and I want to make sure that I won't get caught by the credit facility. You'll read the debenture, you'll realize, wait a minute, nothing here in this debenture has crystallized. So these assets are free at this moment in time. And that's how you will eventually, that's how most scenarios work with movables. It's always a matter of what's in the security agreement, and you don't have to worry in that regard. And then the individual who goes to the store to buy, you know, paint, lumber, whatever supplies, they don't have to worry about it either because there's been no crystallization. In terms of patents and everything else, movables under the law of St. Lucia describes everything that isn't immovable. So if it's not hard land, it's everything else. So you can literally secure anything. If you want to have a patent, you want to have a trademark, and you want to put some sort of security interest on that, you can. No one's going to stop you. The whole idea is whatever we as business people, society deem valuable and are willing to lend money on or give credit on, we can give a security for that credit and it'll just be registered. But yeah, when it comes to things, assets coming in and coming out, movables that move around in the business, as I said, unless there's a specific charge, say for a vehicle or something else, when a company gives a debenture, it only kicks in and crystallizes is the word that's used upon a trigger event. And that's the only time as a creditor you have to be worried.
We happy here? Any other questions? Well, I think not.
Brian, can I just ask a question about neither of these two things, but you can answer. As you know, these two bills were part of the World Bank's push to, have greater access to capital in the country, and they've been really, doing a lot of work to get there. I think the third was the consumer credit bill. So where exactly are we on that one?
Not with me.
That's
from Brian.
Yeah.
I think the third one you're talking about was the foreclosure legislation. And we know that one is nowhere, so to speak. The consumer protection bill.
No, not the protection, not the protection. It was just the one that was intended to set up
the credit reporting bill. Okay, the last was that the Chamber with the Bankers Association addressed and met with the parliamentary subcommittee that was set up to look at that bill. And we made our comments on that bill. Primarily, we were, I would have to find my last set of comments, which I could share with you. What I found interesting was that there's parliamentarians who were there, including Dr. Hilaire, Philip J. Pierre, Guy Joseph, Bradley Felix, and the chair of the committee was Stevenson King. Their concern was really focused on how this affected, again, the average St. Lucian who was not particularly familiar with a lot of the processes and procedures. I will share my notes with you to let you know what the main comments are, because I did make a report on it. And in essence, they were supposed to look at our comments, which sought to tweak some areas in the bill, because we thought it was not particularly well crafted in some areas. And they were to sit in committee and make recommendations to the drafters. I made the point strongly that whilst we supported harmonized legislation, we never thought that harmonized meant identical. And so we felt that we could maintain the OECS nature of the bill, even if there were some differences in what St. Lucia passed. So that had to be taken up. But I don't remember exactly the particular points we raised. That was before the Christmas season. But that was one time when they actually convened a parliamentary subcommittee to hear from the business community. Let me see if I could find it right now, and I could email to you what we did.
Okay, all right. I just thought the three of them were being pushed by the same bodies, but they didn't seem to bring water into this one. Maybe they ran out of money.
Well, also, I hope they have enough money to pay you on this one.
Yeah, no, me and the government are good on this one. We're good. We're
okay,
good.
okay, good. But let me therefore, if we have no more questions, let me thank you, Mr. McNamara, for taking time.
My pleasure.
And for going through this in such great detail and clarity. And I'm giving us that information. Let me thank Sharma at the Competitiveness and the Productivity in the Private Sector and Competitiveness Committee for so willingly this presentation when I called for it. Whilst the members who registered, quite a few of them have not shown up, I will be sharing this recording with them because I think it is extremely informative and they must be aware of this. I think often we complain when we are not given the opportunity to be part of a drafting and a legislative enactment process. And when we do get the opportunity, we don't always respond as we should. But we have had the opportunity by having persons involved in the drafting stage from early on. I know you've presented and addressed the Institute of Accountants, and I know there may be opportunities for other presentations, but I really do thank you. One request is a request for slides, for your slides. If you don't mind sharing the slides, we will share it with the members as well and make it available to them. But I really want to say a heartfelt thank you on behalf of the Chamber of Commerce and all its members. Clearly, a lot of work has gone into that. I think it is extremely positive the way we have invited participation and comments and input from a wide source. So thank you very much, Boza. Thank you very much, Shama. Ladies and gentlemen, thank you for attending, and we will share the slides as soon as we get them, and we will make the video available on our website to all members. Thank you very much, and have a good day.
Thank you.
Thank you, Bota.
My pleasure. Thank you, everyone.